Kerry Brooks. Thank you for watching this video presentation on the topic of mean what you say and say what you mean. Before I get to the heart of this issue, I want to give you a little bit of background about what it was like when I was coming up in the practice and doing my apprenticeship. During my apprenticeship, I was instructed that the scope of protection under a patent was defined by the claims, but a specification needed to be included in the application along with the claims, and that specification had several purposes. One was to provide a written disclosure for supporting the terms that were used in the claims. They didn't have to provide literal support, but provided that a person skilled in the art would understand that the inventor was in possession of the claim subject matter at the time the application was filed. The specification also had to provide an enablement to teach a person skilled in the art how to make and use the invention. And also there had to be a best mode disclosed somewhere in the specification. But beyond those purposes, the specification was considered to be illustrative of what could be within the scope of the claims. Now, it's still true that the scope of protection under a patent is defined by the claims. But the situation is a little bit more complicated than it was when I first started. And that's because a number of courts in different areas have developed a textualist approach to construing documents such as statutes or contracts even. And the same has occurred in the Federal Circuit regarding construing patent claims. So it's very, very important for attorneys involved in patent preparation and prosecution to examine every sentence and to make sure that they mean what they say and say what they mean. Otherwise, disastrous unintended consequences can occur. Well, why is that so? Well, let's take a look at the Phillips case. And the Phillips case is important for a variety of reasons, but one reason less well understood by most practitioners is that in Phillips, for the first time, an en banc panel of the Federal Circuit signaled that the words of patent claims could not be interpreted in a manner divorced from the context of the entire patent. And in doing so, the Federal Circuit elevated the patent specification as the primary guide for claim construction. And what is stated in the written description may be controlling regarding the scope of the claims. The Phillips court said that the specification may reveal an intentional disclaimer or disavowal of claim scope by the inventor. In that instance, the inventor has dictated the correct claim scope. And the inventor's intention, as expressed in the specification, is regarded as dispositive. That means what's in the specification can actually trump what's in the claims. The issue of patent claim interpretation is a question of law, so the Phillips decision ushered in a new era where courts could go so far as to dispose of patent cases without a jury if, in the court's view, the patent specification supported a narrow claim interpretation under which no reasonable jury could find infringement. Now, other Federal Circuit cases elevated the role of remarks and statements made during prosecution in construing claims, holding that the prosecution history limits the interpretation of claim terms so as to exclude any interpretation that was disclaimed during prosecution. So it's extremely important for attorneys involved in patent prep and prosecution to make certain regarding every sentence and every limitation in their claims that they mean what they say and say what they mean. Otherwise, disastrous, unintended results can occur. Thank you so much for watching this video presentation on this topic. I hope that you found it helpful.